As HR leaders and functional line managers, decisions that we make daily can have legal implications. From recruitment to onboarding, discipline to termination, every step must be in alignment with the law. With this, we have put together legal training for HRs and line managers. This course is designed to give you the knowledge and clarity to lead lawfully. We will break down Ghana's Labor Act 651 in a simple, practical way. You will learn what the law actually says and what that means for your work. Do you know the probationary periods or how to properly document issues to prevent future legal risks? These are the things that are really important as a leader and to safeguard your organization. Whether you're a seasoned manager or a new business executive, this course is simply designed for you. To join our next cohort, call or WhatsApp 020-800-7585. It's your time to hop on the legal train.
All right. Good morning, good afternoon, and good evening, depending on where you are joining or listening in from. My name is Silas Etiahiniapia, and I'll be your moderator for this session. So before I jump right into it, I want to hear from you. Let us know where you are listening in from. You can mention your first name, then you attach wherever you are listening to us from. So it can be Silas from East Legon. It can be Ajua from Kaswa. Just let us know where you are listening in from today. Today, we are very excited to have you join in as we are here to explore a very, very important topic. We are here to talk about what makes a contract of employment valid, especially under Ghana's Labor Act, which is the Act 651. Today, we are going to look at specifically the part 4 of this act. And our goal today is very, very simple. We want to break down the law into practical insights so that you are able to apply it in, first of all, your workplace, and then secondly, personally. So whether you are an employer or you are an employee, this particular program is specifically made for you. So our interactive Q&A session will be starting very, very shortly as I prepare to introduce our speakers. So feel free to drop your questions in the comment section. And after our experts have done due diligence to the topic, we'll open the floor for each and every one of you to be able to ask your questions. So put your questions in the comment section and I'll read them out during the Q&A period. So today we are privileged to have two distinguished speakers with us. And then the first on our bill is Kofi Oti Edinkra Jr. Kofi is an accomplished attorney, certified mediator, and arbitrator with extensive experience in labor law, dispute resolution, and legal reform. He has consulted for organizations such as the ILO, World Bank, GIZ, and OSIWA, and played key roles in drafting major Ghanaian legislations, including amendments to the National Health Insurance and Mental Health Acts. A passionate educator, Kofi teaches at the UPSA Law School and has facilitated numerous capacity building workshops for law enforcement, industry, and public institutions. Kofi, you're welcome to today's session. Hello, Kofi, can you hear me? Kofi, if you are speaking, your mic is muted. Okay, so whilst we assist Kofi with the technical challenges currently facing, I'll introduce our next speaker. Our next speaker is in the person of Dr. Jeff Bassey. Dr. Bassey is the founder of the HR Certification Center and the Institute of Leadership and Strategy. He has consulted and trained for over 200 organizations, including the Bank of Ghana, MTN, Newmont Ghana, Ghana Revenue Authority, Ghana Stock Exchange, Kempinski Hotel, Coca-Cola, and Tallow Oil. Ladies and gentlemen, let's welcome Dr. Jeff Bassey. Doc, it's nice to have you on the call today.
Yeah, indeed, it's a privilege to be on the call, and a very good evening to our August listeners. We pray and hope that in the next 1 hour we can share some deep thoughts on the practice of labor regulation or labor laws in Ghana. Thank you.
Okay, thank you very much, Dr. Bassey. So, Doc, I'll take an opening remark from you. So today we are going to look at what exactly makes a contract valid, especially under the labor laws of Ghana. And as someone who has been in this field for a while, I want you to just give us a general overview or an opening remark, your take on this particular topic, and why you feel it's very important for both employers and employees to be on the same page for this particular topic.
Very well. I was hoping that you would allow my senior colleague to have the first bite, but I think because of his internet challenge. Well, yes. My intro would be that, as my followers will probably have heard me say, HR practice, or let me generalize it to say, management of people is heavily legally regulated, and so cannot be done at the whims of an employer or a manager. You cannot just get up and at your whims and caprices you decide how you conduct people management. Now, as to the specific question as to the requirement of a contract or what makes a contract valid. I'm sure we are going to get into the details, yes, but very simply, the Labor Act looks at a contract as an agreement between two or more persons for the fulfillment of certain obligations, failing which there would be liabilities. And specifically, when you look at Section 175, it talks about a contract can be express or oral, and if expressed, written or it can be written or oral, and it can also be expressed or implied, And so, to the extent that contract can even be implied, I would say that maybe there are no special requirements to what makes a contract valid in Ghana, as much as in the spirit of the Labor Act, there are certain provisions we'll be looking at, specifically sections 12, 13. Maybe we'll be interested in the Schedule 1 that talks about the specific provisions of what a contract layout should be. And then, depending on how much time allows us, we probably will be speaking to sections like 73, 74, 75, 78, that sought to distinguish between different types of contracts, be it fixed time contract, what the law likes to call a temporary contract, or casual or part-time or permanent contract. I'm sure we would get into all of those specific details. Otherwise, a contract can be expressed or implied, and I do not see any special requirements laid out, so long as the two of them agree or conduct themselves in a certain manner. Contract it becomes enforceable, at the law courts. That's what I can say as an introductory remark.
Okay, thank you very much, Jeff. Kofi, if you can hear me, let's take your opening remark.
Yes. Okay, thank you very much. And let me confirm, can you hear me?
Yes, we can hear you very well now.
Can you hear me?
Yes, Kofi, we can hear you loud and clear.
Great. So,
okay.
So as the agreement, but I'm sure for our purposes here, us and viewers, listeners, a contract is an agreement between two parties that the law will enforce, to put it simply. A contract is because it's not every agreement between two parties that the law may enforce, especially if you have, situations where one party was forced into the contract, which therefore means that parties. So in its most basic form, a contract is an agreement between two parties that the law will enforce. So if you are talking about an employment contract, then you are talking about a contract between a prospective employer and a prospective employee or worker regarding specific duties that the worker is going to do in return for the employer also performing certain duties or responsibilities towards the worker. So in its most basic form, that's what I'll say as my opening remarks. Agreement that the law will enforce. And of course, as we go along, we will see the requirements of, in our case, an employment contract. So that's what I'll say as my opening remarks. Thank you.
Okay, thank you very much, Kofi. So before we start with the questions we have on our bill, I'd like to remind our listeners or our audience that this webinar is proudly brought to you by the HR Certification Center. And I can see a few people in the comment section. Daniel says, great to be here. Daniel, it's nice to have you. Rafia, you are welcome to the show. Augustus, it's nice to have you all. So, Kofi, this first question will be to you. So in your opening remark, you made mention that a contract is an agreement between two parties that the law actually enforces. And for employment contract is between a prospective employer and an employee. So in this particular scenario, can an employer be penalized for possibly not issuing a contract within the prescribed period, where, for instance, you are supposed to issue a contract to an employee within this period of time of them working, but you don't do that? Is there any law or any section in the Act that allows the employer to be penalized for doing something of that sort?
Okay, that's an interesting question. That's an interesting question. And what I'll say in the best part. Oh, I'm sorry. Did you? I'm sorry. Did I cut you off?
No. We are listening to you, sir.
So, if we take the first part of the Labor Act, a contract has to be in writing. It has to be in writing, and that contract contains the terms and conditions of the employment relationship. So by the time you are beginning your employment, or by the time you are starting the employment relationship, as an employer, you have to give your worker their contract of employment, ordinarily in writing. Unfortunately, whilst this requirement is there in the law, no specific penalties have been put in the law for not giving the worker their. It is a requirement, but no specific sanctions have been put in place. And we also don't have a specific time period. So what it means ordinarily is that as soon as possible, you should be given your employment contract. However, that doesn't mean that the employer will go scot-free. So for example, if you have some problems, if you run into problems in the employment relationship, like I always like to say that in practice, in the working relationship, both parties can get away with a lot of things until there's an issue which gets before the authorities. Yes. Authorities may be the Labor Commission or the Chief Labor Officer or the court. And so if you haven't given the employment contract to the worker, for example, and then you start to take disciplinary measures against them, at the end of the day, depending on the issue, you may be wasting your time because you yourself haven't fulfilled all righteousness, if I should put it that way. And so based on what are you going to punish the worker? And if they also decide to take you on, you also end up in trouble. So in a nutshell, yes, you are supposed to be given your employment contract. In fact, at the beginning of the relationship. However, we don't have a specific time that it must be given within a week or a month. And there are no specific sanctions, but that doesn't mean there are no legal consequences for not giving the employer, for not giving the contract.
Okay. Wow, that's very eye-opening. Jeff, Dr. Bassi, from what Kofi said, I've come to understand that there's really no time period where the employer can issue out a contract. But in your opening remark, you also made mention that a contract can either be written or oral. It can either be expressed or implied. So even if the employer does not issue any form of contract, based on implication, is there some form of contract between an employer and an employee, even though there's not been anything written or shared with the employee? Dr. Bassi?
Yes, we would assume so. Just as Kofi had mentioned, and I'm happy with the last bit he mentioned, that in the absence of a contract, both parties can get away with a lot of things. And let me say, the one that is more disadvantaged, in my candid opinion, will be the employer. in my candid opinion, in the absence of written contracts between the two, the employee in particular can get away with so many things. I always say that you cannot just declare an act as an offense when it is not being documented, or in this case, if it is not being put in policy. And so, for instance, if stealing goods was not in our criminal code, all goat thieves would have been walking around as angels, right? So we justice is not delivered on morality or common sense or emotions or religious beliefs, if you may. So if you have not put it there, rules that will guide the employee, you can get away with so many things. All right. Yes. So the Labor Act, in trying to give interpretations to certain sections, if you may, in Section 175, actually make mention of. I want to sort of, if you would pardon me if I can read it verbatim. I don't know if you want to allow me
Yes,
to do
please.
that. It says, so I'm reading from section 175 under the title Interpretation. And it says, a contract of employment means a contract of service, whether express or implied, and if express, whether oral or in writing. And the understanding we give it is that not saying no is tantamount to saying yes. If you open your doors to somebody to come in and you give the person a job to do, probably provide work equipment under your supervision, the person does the work, and at the end of the day, you give the person some remuneration. By the conduct of two of you, there's a contract, though not written on paper. And the Labor Act says clearly that that is the interpretation it gives to the word a contract. So I would say yes, even if it is not written with specifics so indicated in the sessions I had mentioned earlier on, that I'm sure if time allows it, we're going to explore, it would still be enforceable at law. And let me say that I have led a client at the National Labor Commission. And just when we started sitting, hearing, if you have any experience with the commission, you would first go through, what we call the conciliation committee. There's a group that would try to, sort of pre-trial, get two of you to come to an agreement or a consensus of an issue. Right at that stage, the employer would make a statement as, we've not even given them any written contract, so there's no contract between us. And I started laughing. I'm like, okay. I'm sure these guys do not even understand the whole idea of contract and why we are here. And the Labor Commission did agree with me that the fact that there was nothing documented and signed between the two of them would not mean that there was no contract that existed. So we went ahead to conduct all the other tests that would verify or that would support my position that there indeed was a contract, because the employer did avail his premises or office to these workers involved, did give them work to do. They performed the job. The employer did pay them for the work they had done by the conduct of the employer. Though there was nothing so written on paper, there was a contract. And once they fulfilled all the conditions of contract of service, these were guys that were working under the directive of an employer. They were trained. They were given work equipment. They had worked 40 hours a week. They had a permanent relationship or an ongoing relationship with the employer. They didn't have the opportunity of making profit or loss. They were on fixed pay. Once all of those litmus tests was fulfilled, the Labor Commission did agree that a contract existed, and removing them without adherence to sections 15 and, if you may, 62 of the Labor Act, those terminations were considered unfair terminations.
Wow. Thank you very much, Jeff. Wow. That was very, very eye-opening. Kofi, I want to find out this from you. Let's assume that a contract has been presented to an employee, and this is a written contract. I've heard about stories where there are very interesting items on the contracts of employees where you can hear you get maybe one day leave within the first period. The second year you get 5 days, and then it progresses that way. Kofi, I want to find out from you. According to the Labor Act of Ghana, what are the legal requirements for a written contract of employment?
Okay, thank you. So if we are talking about labor law in Ghana, if you are giving somebody a written contract of employment, there are basic features that should exist in that contract. These are first, what you require. So this is speaking from the view of an employer who is giving a contract to an employee. The contract should contain what you expect the employee to do, where they are supposed to do it from, because some employers have different information. So maybe a branch in Accra, Kumasi, wherever that it is. How many hours of work they are required to perform. Their rest periods. These rest periods include both rest during the day, that's what we think of as lunchtime or break time, and rest in between days or rest in between working weeks. And then how much they are going to receive as remuneration or compensation, whether per week or per month, depending on the nature of the job, or even if it is seasonal. Although a lot of seasonal workers don't usually get written contracts. And of course, if there are other manuals in the organization, in your organization that are relevant to the work, you can incorporate those manuals by referring to them. That for the specifics of this task, your task shall be as contained in this manual, so that you don't have to copy and paste the whole manual into the contract.
Contract, yeah.
So basically, what you require from them, as in their duties, how long they are going to do their duties for, where they are going to perform their duties, their rest periods, their remuneration or compensation, and reference to any other documentation that is relevant to their work. Of course, there are some other things such as discipline and the rest, but for those ones, usually they are referred to, usually they are contained in a disciplinary manual or handbook or something like that. But let me add that the Labor Act, that's Act 651, that is currently in operation, is the basic terms of employment. So whatever you put in your contract of employment for your worker, if it contains harsher terms than are contained in Act 651, in practice, if nobody says anything, nobody goes to report, you may get away with it, as I like to say. However, it doesn't mean that that contract of employment is legal. If there's an issue, those parts of your contract that you give the worker will be shut down. So the Act 651 is the basic terms of employment for every worker in this country. It provides a basic blueprint. So your terms of employment should either be equal to that contained in Act 651 or better, but it cannot be less. So when 10 days leave in a year, because Act 651 actually requires a minimum of 15 days. That's just an example. Thank you.
Thank you very much, Kofi. Jeff, would you like to add your voice to that?
Salas, were you referring to me?
Yes, please.
Come again on that, please.
So I was asking if you'd like to add your voice to what Kofi just said.
I largely agree with Kofi. So let's go to the next question.
All right. So, Jeff, I'd like us to talk a bit about probation. Now, we have looked at contract of employment. After you have served the person with a contract, whether written, and now we've come to understand that it can also be implied. What is the probation period? How long can an employee be lawfully kept on probation? I've heard about people being on probation for 2 years on renewable basis and very, very interesting things. Lawfully, how long can an employee be kept on probation?
Is that question coming to me, please?
Yes, please.
Well, it's interesting that you have heard that 2 people have been on probation for 2 years renewable. No probation is considered to be renewable per se. I will try to explain the dynamics.
Okay.
Maybe you're looking at the fixed term renewable contract, but if it is probation, no specific mention regarding duration is on or is in the labor regulation of Ghana. I mean, to the best of my knowledge, maybe my colleague might provide a different perspective to it. But as far as I am concerned, the law hasn't prescribed anything. Probably we'll refer to or we will resort to standard practice. The practice, as it were, had always been about 6 months or so in the private sector. I have seen 9 months, 1 year in the public sector. Now, as much as there is no upper ceiling on probation, I want to believe that if an employer should put an employee on, say, 2-year probation, law is founded on reasonability. That is more like labor exploitation. How do you want to study somebody for up to 2 years before you know whether or not you want to work with the person? That notwithstanding, we advise employers that when you are issuing out contracts, do have specific provisions on probation, on duration or from duration to notice provision before the probationary period is terminated, etc. But most importantly, let me say this: there are employers who haphazardly or arbitrarily, rather, would want to keep employees on probation for a period even beyond what is agreed without any prior notice. If you and I agree that you are trying me for 6 months, and by the way, it is not only the employee who is being put on probation, the employee also would have to be looking at the employer to know, is this a person I want to, or is this an organization I will want to work for? In other words, the termination of either party is the right of both of them. The employee during probation can also provide notice as so agreed between two of them and then leave. But most of the time when we talk about probation, it is the employer who is putting the employee on trial or on probation. And I would say that if the probationary period is getting close, or by the time it expires, employers have to do one of 3 things. You are either confirming the employee, relieving the employee of duty on or before the expiration of the agreed period or the agreed date. Otherwise, you are extending the probationary period. But I insist that either of the 3 must be done on or before the expiration of the probationary contract. And I have a case where an employer, I think GCB Bank or so was what was involved in this, where an employer would allow employees to exceed probationary period. So let's say that you are employed on, say, 1st of January. Well, 1st of January is a holiday in Ghana. So let's say 2nd of January, and your probation period ends on, say, June 30. And then it is only in July 15 or on July 15, the employer now says that, well, we cannot work with you and we want you to go. No. By the midnight of the 30th of June, since 2 of you agreed it's going to be 6 months, the employee automatically sort of have become an employee. The probationary staff have become an employee, because I kept saying that not saying no is tantamount to saying yes. If you are telling me you are trying me for 6 months and the 6 months is due, and you did not tell me that you are not relieving me to go, then you have drifted, in my candid opinion, you have drifted into the arena of implied contract. If by 1st July, which is a day after the agreed date of 30th June, then I have become your employee sort of by your conduct because you have not stopped me from coming to your workplace. So I would simply say that the employer and the employee should agree on duration of probation, document it, and all the other conditions, notice provision and all of that during the probationary period should be put in the agreement. And if for any reason you want to extend the probationary period, it must be done on or before. In fact, you're on safer ground if you do it before the probationary period expires. So that is what I got to say. I don't know what my colleague have to add to this.
Wow. Kofi, if you can add,
To add to that, I was smiling when yes,
yes, I saw you smiling
I
a
was
lot.
smiling when Dr. Bate was where I was put. I was supposedly on a 2-year probationary period because
Oh, okay.
it was the probation being 2 years without notice took place 3 months after the 2-year period had ended. And so what I did was and of course I do not recommend this for everyone. But what I did was to refuse, because if you were listening to what Dr. Batsey said, by that time I was legally a permanent worker in the meeting. That meeting should be scheduled for those that are not permanent workers yet, and by reason of how they have conducted themselves. I am a permanent employee, and so if they have any disagreement with that, I'm very okay with that going to the National Labour Commission. That was the last I heard of it, to be on something. Your leg has to be on something. So yes, everything Dr. Bassey said is absolutely correct. And I just want to add that for those of you who do not know, the current Labour Act, Act 651, when we attended, I can't remember which of the meetings we attended for the review, but in one of the sessions, one thing that came up and is currently under consideration is the use of temporary arrangements, temporary workers, or trying to use probationary periods and things like that to keep workers in your employ without treating them as permanent staff. The realization is that the current provisions in Act 651, although they are effective, but as Dr. Bassey said earlier, a lot of things are due to interpretation. So they are trying to tighten them up and make them more stringent to avoid situations where employers use certain tactics to prevent you from becoming a permanent worker in quotes. Because permanent worker obviously that's what I'll add to it.
Wow. Kofi, it's very interesting how you were put on a supposed 2 years probation. Very, very, very interesting. I thought the story I was hearing was not too true, but it seems like there are some employers who try to find ways and means to keep the talent in their organization without treating them as permanent staff or permanent employees. But still on probation, Kofi, I want to throw this to you. Is it mandatory for an organization to have probation for an employee or a new staff before enrolling them or maybe onboarding them into their system? Is it mandatory?
Okay, that's a good question. And the simple answer is no, it is not mandatory. The basic terms of employment, which is Act 651, does not mandate probation. And that is why if you go around, not every employer starts every employee or category of employee with a probationary period. It's common, but it is not universal. But probationary periods are allowed. So that's what I would say. They are allowed, but they are not mandatory. It is only fair that if you invest in your time and labor, making it available to an employer, that some period be given for you to try out to see whether you are a good fit for each other. But it is not man. Everything has to be spelled out ahead of time. There should be no surprises. And as the law requires, the each party to have, for there to be a good balance of
okay.
So that's what I would say.
All right. So if I understand, it's more like a way for both the employer and employee to understand each other and have a good relationship before deciding whether it's good for us to work together or not. Okay, so Kofi, building on the same point,
yes.
Still on probation, what does someone under probation, what kind of rights do they have under the law? Because I've heard a lot of very, very interesting things. Kofi, if I really tell you the things I've been hearing, so you come to hear stories about people under probation, and because they are not treated as permanent staff, there are very, very, very interesting things that have been, for lack of better words, imposed on them to do. Lawfully, what are some of the rights that people under probation have under the law?
Okay, thank you. And this again, it adds to the very important questions that you are asking this evening. Let me just say this, that largely, of course, not everything, but largely speaking, the worker who is on probation has similar rights to permanent staff. The things that permanent staff may be entitled to, that a worker on probation may not be entitled to. So what do I mean? The fact that you're a probationary worker doesn't mean that if the employment or if the organization does not require work beyond 8 hours, you should intentionally be working beyond 8 hours to see whether you have a good spirit, in quotes, as some employer might say. No, or that you should not receive or that you should not receive your salary. In some places you don't receive salary for 3 months.
Yes.
In the name of being on probation or things like that. Let me tell or that you are not entitled to lunch break. So those are basic things. Those are basic things. So employers who guarantee loans for their staff. So you and your bank, as you're an employee, you have your own bank. Your bank is different from your employer's bank. You apply for a loan. Some banks, if you want a personal loan, they require a guarantee from your employers. If you are not permanent staff, you are not entitled to those things. So they will not guarantee loans for you. That is a different thing. Or where there's a provident fund scheme. Some provident fund schemes are not part of tier 1, tier 2 SNET. Yes. So those are beyond basic. But even that, I can tell you that ordinarily speaking, of course, there's a letter of the law, and then there's a practice of industry. And usually provident fund schemes, you even want as much funds in it as possible. You are allowed to join the provident fund schemes. Your deduction starts almost immediately, even though the letter of the law is silent about that. But so if you look at it, there's a clear difference between allowing you the required rest periods, allowing you to go on leave, and of course, if you're on probation, you've not worked for 1 year yet. So your leave, if you are going to be in leave, usually will be prorated because you're entitled to leave after 1 continuous year of service. But you see, going on leave, allowed rest periods and things, those are basic. And those are different from your employer guaranteeing a loan for you. So if you are employed as a certain category, what that category of worker in that organization is entitled to, largely you are entitled to with regards to the basic things. And sometimes those go beyond the basic. But for certain things like guaranteeing loans and things that require special relationships, those are the things that you may not be entitled to yet as someone on probation.
Wow. Okay. This is very interesting, because from the general practice that is out there, a lot of people use probation. A lot of employers use probation period as a means of denying some privileges to employees, just based on the basis that they are not permanent staff. I am very, very grateful that lawyer Edin Kras be able to throw more light on that. Jeff, I want us to move away from probation because of time. I know there are a lot of questions on probation, but I want us to talk a bit about remuneration and deductions. When is it legal for employers to deduct from an employee's salary?
All right, thank you. Generally, we are not supposed to be deducting. I use the word generally.
Okay.
But of course, every good rule does have an exception. Now, when you look at Section 69 of the Labor Act of Ghana, there is more like an embargo on even pecuniary sanctions. You cannot be punishing employees by deducting monies from their pay, except for reasons stated in Section 70. So I always encourage people who want to understand issues of deductions to read Section 69 in tandem with Section 70, that you shall not impose pecuniary sanction for whatsoever the reason. This is what is stated in Section 69, except for what is in 70. Now, 70 is simply talking about issues of union dues, deductions, and etc. Now, largely, I'm happy the good lawyer mentioned the spirit of the law. Largely, the understanding is that the employer is barred from arbitrarily touching an employee's pay. For instance, an employee is late to work, and we say fine punishment for the employee, but not taking money from the employee's pay. And people would ask you, what sort of punishment? An inexhaustive list of punishment. Even if you are going through the progressive discipline, the fact that an employee have been warned, reprimanded, maybe threat of termination, progressively that employee can be removed if he continues repeating that. So you are not supposed to be touching an employee's pay in the name of deductions, except for reasons stated in Section 70. And I've already mentioned that it concerns issues of union deductions, and sometimes when the employer can really prove that there is a loss as a result of the employee's negligence. And the word is, you must prove that there's a financial loss as a result of that. Now, so much so that even if you looked at the supporting legislation, LI 1833, where you can put an employee on interdiction for up to 6 months, that's what the law says, you may only deduct up to half of the employee's pay till such time where culpability is proven or the employee is proven guilty. We all know the presumption of innocence so stated in the Constitution of Ghana, subject to which is every other law, including the Labor Act we are discussing. The labor law, the Constitution presumes innocence until proven guilty. I know what we do in our organizations is guilty until proven innocent. You know. Okay, so to that extent, I would say, hey, you don't have the liberty to be imposing pecuniary sanctions or deducting monies from employees' pay. And I gave two for the sake of our listeners. You want to read section 69 and 70, and I've also given rare cases where you can prove a loss, and even if you prove that loss, to the extent that to the point that you even suspect a wrongdoing that might have cost the company money, say suspected case of stealing, till the employee is taken through exhaustively taken through the disciplinary process, and you would have proven culpability, he is considered innocent. So
Wow.
you would have to, you cannot take or withhold more than 50% of the employee's pay until you have proven culpability. To the extent that if the employee is exonerated after the disciplinary process, you would have to even restore all the monies that have been so deducted from the employee's pay. So generally, employers do not have the liberty at their whims arbitrarily touching employees' remuneration, particularly the ones that are the monthly salaries and the rest. Maybe if it's a daily wage, the guy hasn't come to work, he hasn't earned the money. But so long as we agree that this is what you are supposed to pay at the end of the month, you can't even say you haven't worked for 3 days in the month, therefore I'm taking it from your money. It's illegal. You have to find punishment for that employee, including policies that regulate vacation of post. But you cannot be touching the employees' remuneration. And it is so sacrosantly stated in Section 69 of the Labor Act.
Wow. Lawyer Dinkra. Yeah, I like to hear you. What do you have
Thank
to
you.
add to it?
Honestly, yes. Honestly, we cannot emphasize this enough. There are too many cases of employers making deductions from employees' remuneration on a whim. And I always call these cases unnecessary. So you'll be at the Labor Commission and they'll call you, come and arbitrate a dispute. And what is it? It started with an employee doing something, and then the employer, I don't want to mention certain categories of employers, although I'm sure Dr. Bassi knows the type that like to do that a lot. But some disagreement or some unhappiness, that something that the employee did that the employer is not happy with, and then they will just withhold a part of your salary. Or that thing where you wait, you will not hear anything, you will just receive your salary at the end of the month, and it is my day this day you came to work.
Yes, that happens a lot.
At 10 instead of 8, or you did this instead of. The question is, if you don't, I mean, what is the value of coming to work at 10 as opposed to how much you took out of the person? What is the basis for making that deduction? Because the employee has not, and a lot of these cases, it's not that the employee has directly caused financial full inquiry to prove it, the employer. And frankly, I mean, yes, the work that we do, when you bring trouble, we'll work on it for you. But we are not happy to, it's not something that we encourage. So some of these as we can be heard today, I would suggest one that if you're an employer, you stop that, because if gradually as employees become apprised of their rights and they start taking you on by before the authorities, that is productive time you will spend defending yourself. Even if you are going to get rid of the employee, we are also going to spend time and resources defending yourself or trying to solve a problem that could have been solved from the very beginning by not doing it in the first place. So yes, as Dr. Basi said, I was going to hear that keyword, the action, as and when we feel we can, because we are the ones who are paying. So that's what I would add to it. Thank you.
Wow, thank you so much. And what I have come to understand just from the little submission from both Dr. Jeff Bassi and lawyer Kofi Edinkra is that though you might be an employer who is employing another talent into your organization, you can't do these things based on your own feelings or based on your own understanding of what is right or not. There are laws that govern the employment contract of each and every talent you bring into your organization. I have so many questions that I want to ask, but at the beginning, I promised my audience that I am going to allow them to ask their questions. And from the comment section, I can see a lot of questions that have been put there. So before I read the questions, let's just take a quick word from our sponsors, which is the HR Certification Center. And we'll come back and we'll answer each and every question we have in the comment section. We'll be back.
As HR leaders and functional line managers, decisions that we make daily can have legal implications. From recruitment to onboarding, discipline to termination, every step must be in alignment with the law. With this, we have put together legal training for HRs and line managers. This course is designed to give you the knowledge and clarity to lead lawfully. We will break down Ghana's Labor Act 651 in a simple, practical way. You will learn what the law actually says and what that means for your work. Do you know the probationary periods? Or how to properly document issues to prevent future legal risks? These are the things that are really important as a leader and to safeguard your organization. Whether you're a seasoned manager or a new business executive, this course is simply designed for you. To join our next cohort, call or WhatsApp 020-800-7585. It's your time to hop on the legal train.
Okay, welcome back. If you are now joining us, this is the Q&A on labor laws, proudly brought to you by the HR Certification Center. And today, the topic we've been discussing has been on the topic of what makes a contract of employment valid under Ghana's Labor Act 651. So, from the comment section, I have a few questions, and I am going to do well to read as many of them as possible. So, Bennett writes, I heard you can't engage someone working in an organization for more than 6 months without appointment letter or contract. I need clarification, please. Jeff, can you take this, please?
Right. Thank you. Indeed, an employment contract may not be in writing. I use the word may not. It is only in Section 12 that the Labor Act, encourages. I'll use the word encourages because of prima facie evidence, for want of a composite expression, and for avoidance of doubt. let me read something in section 12 for us. It's titled Contract of Employment. It said the employment of a worker by an employer for a period of 6 months or more, or for a number of working days equivalent to 6 months or more within a year, shall be secured by a written contract of employment. Okay, so that is what the law actually uh, um, mentions, that if the relationship will be 6 months or more. It didn't say that within 6 months you must. It said if the relationship was 6 months or more, it must be secured by a written contract. And part 2 says a contract of employment shall be expressed in clear terms the rights and obligations of their parties. That will be in addition to what is stated in sessions 8, 9, 10, and 11 of the Liberal Act. So that is what I have to say to the person who asked the question. If the relationship would be 6 months or more, and maybe section 13 may also be of interest to you, that subject to the terms and conditions of a contract of employment between an employer and a worker, the employer shall within 2 months after the commencement of the employment furnish the worker with written statement of particulars, and those particulars are what are stated in Schedule 1. When you get to the back, you turn to the back of the or the towards the end of the Labor Act, you'll find various schedules there: Schedule 1, Schedule 2. So in Schedule 1, there are provisions or requirement that must be inculcated into the employment contract. And let me, if you can kindly allow me to say, those requirements are very basic, very, very basic, because when you start having issues and an employee challenges them at the law court, you realize that you need more provisions or more stuff in the contract to protect the employer in particular. So, for instance, there's in Schedule 1, it was totally silent on issues of non-compete agreement, confidentiality, trade secrets, executive contract that we must inculcate, stuff like what's the name, golden parachute. All of those things are quite silent. And so typically when we are teaching employment contract, like the upcoming legal training, there are very important additions we advise employers to take care of, just so they will be fully protected in the event that there are dispute or issues that must end up in a third party arbiter, etc. So that's what I've got to say to the person who asked the question.
All right. Thank you very much, Dr. Bassi. Because of time, I'll move to the next question. And Kofi, Emanuela wants to know, supposing there's a situation which the employer deems it necessary to reissue a contract to an employee with new terms and conditions, what are the do's and don'ts regarding this change? Also, what are the legal consequences of an employer reducing the employee's salary in the new contract, especially where the scope of the initial job title is not fundamentally or substantially different from the new one? Kofi, this is for you.
Okay. So so right out the gate, let me say that you cannot review the employment conditions of a worker and make them worse. And so if you are going to change the contract of employment, that is basically changing the relationship that exists between the two parties, the employer and the employee. So first, it's a new contract. I don't want to get I want to keep it sealed. I don't know if it is an a rearrangement, an amalgamation, or a disguised redundancy or something like that. But I mean, simply put, if the terms and conditions of employment, they cannot be worse.
Cannot be worse. Okay.
If the employment contract or the terms of employment are being changed, and the new ones haven't been signed yet, of course, it again has to be something that the two parties have to agree to. If worst case, if you cannot agree, the employment relationship will have to come to an end. And so it always depends. But what is that? So those are the do's and don'ts. You can change, you can enhance the conditions of employment. That is fine. But a don't, and a very big don't, is reviewing them brisk as it used to be. And so we are reviewing everybody's contracts. At first, you were earning 2,000 cedis. Now you'll be earning 1,000. It doesn't work like that. It doesn't work like that. If there are certain conditions that exist that have to cause a change in the business, there are procedures that have to follow, and sometimes third-party authorities have to come in.
Okay.
But if to make it better, that is fine.
So Kofi, what if an employee refuses to sign a contract of that sort?
Yes, so if an employee refuses to sign, then it is either the employer will understand or there will be an impasse. And if there is an impasse, it's one of two things. Either the impasse will have to be resolved by ending up at either the Chief Labor Officer's office or the NLC, or the employment contract may have to come to an end. But it all depends on the reason why a new contract is being offered. If it is just for shaggy, as we say, then you may have to the employer may have to give up, depending on what happens. But if the reason behind it is changes to the business, that's an important matter where you are talking about, when you rearrange and reorganization of the business. And for that one, you have to go, usually the worker, but you have to follow procedures such as going through the process of informing the Chief Labor Officer, who will make sure that the employment contract is ended in a fair manner.
Okay, that's very, very insightful. Jeff, do you have something to add?
Yeah, let me quickly add something. It's a very important area because so many employers do these things and get away with it. You see, Kofi had already explained some exceptional reasons an employer could do that. I always say law is founded on reasonability. But generally, the employer cannot at his whims just make changes to an employment contract. No. Especially when you don't even have novation clause in the original contract that allows either party to come forward with major changes in the contract, etc. You see, the only time we test the efficacy of the law is when people go to court, because Ghanaians don't go to court. We don't, especially on labor issues. I'm sure the good lawyer can attest to the fact that 7, if not 8 out of every 10 cases at the Labor Commission are on issues of termination. So long as you don't terminate the guy, he's still there. He won't go to court. It is when you remove him that they find reasons to go. But you cannot subject, it is called jubilation. You can't worsen the condition of an employee when he's still at post. Except there are fundamental changes, re-engineering, how core business is done, operational changes, and even that, you don't do it at your whims. If it's a unionized environment, you got to go back to the negotiation table. Even if the environment is union-free, you still have to meet the employees, at least through their representatives, and renegotiate. But you don't just sit at your corner as an employer to say, business is not good. You are the risk taker. If business was overly good, were you going to be paying them more? No, you are the risk taker. So you have to go back and do negotiation and etc. Which means that there must be an agreement between the two for any of such thing. But you cannot unilaterally change the terms of a contract of an employee. It's not done. That's what I want to quickly add. Please.
Okay. So, Emanuela, the answer to your question is largely it is something that can be done, but it can't be done just based on the employer's decision. It should be something that first should be agreed on by both the employer and employee. And secondly, you cannot do it to make the employee worse off than they currently are. That's very, very insightful. Now, Jeff, George wants to find out a non-exempt
I'm here, please.
Okay, so George wants to find out a non-exempt employee who is due overtime is not paid, and the employer argues that it goes on recess in the whole month of January, where there's no production, so it covers for the over hours worked during the production times. Is this arrangement permissible under the law or legal?
Okay, is that question coming to me, please?
Yes.
Okay. Generally, let me also read it. I wasn't quite following you. A non-exempt employee is due overtime is not paid, and the employer argues that it goes on recess in the whole month of January. Blah blah blah. Well, let me say that generally, non-exempt staff are not paid overtime. Except we have different understanding of non-exempt rather are paid overtime, and exempt staff is not. And I think the one asking the question is emphatic that a non-exempt staff. So, and I'm trying to get the thrust of the question. Let me confess to our listeners, I'm not in Accra. I'm at the holiday joint somewhere, so concentration is not getting easy. Okay, so let me make sense out of the question. January where there is no production, so it covers for during the is it the no? We cannot take that argument because it is the duty of the employer to provide work. When you look at the responsibilities of an employer so stated in Section 9, it is your duty to provide work. You do not say that because there was no work at a particular month, it nets off, or it should be spread over the rest of the period to say these are the reasons, even if you did overtime, we are not supposed to. Unless the job is sporadic in nature, or it's seasonal, or it's a project-based work. But if it is a job that is supposedly available and continuous, any such arrangement have to be pre-communicated. It doesn't just come and then you say, because this is what has happened, I am taking ABCD decision against you. Now, I remember during the lockdown period or COVID era, Graphic Communications organized a seminar on this thing, and I was fortunate to be one of the resource persons. Whether if there was no force majeure in an employer's contract, an employer can say that because of lockdown, it nets off for your leave. Well, there were very good legal brains there, just like my big brother Kofi. And the conclusion we came to is that leave is for different purposes. If the central government have imposed a confinement to say that there's lockdown, everybody sit home, and you say it is my leave, did I tell you that I want to use my leave to sit in the house? I probably want to use my leave to travel. I will probably want my leave to do A, B, C, D. And so you cannot say that imposition will net off for my leave period as well. And it is from that wisdom I will be imagining that this arrangement with a non-exempt staff will not work. Coupled with Section 9 that imposes on the employer that you have the responsibility to provide work, which spirit we can infer to say that whether or not you provide work, you got to do payment, except the people are on fixed term, like maybe daily wages or weekly wages, or the job is seasonal, project-based, or intermittent or sporadic. If it is continuous available work, you cannot, net off such overtime pay in the name of a particular month workflow, did not go well. That's what I have to say. I don't know what my colleague have to add to this.
Okay. Kofi, is there anything you'd like to add? And as you are answering that, let me just couple it with another question. Someone wants to find out about annual leave. So after you speak on this, then you can talk about that. The question is annual leave after 12 months or 11 months?
Okay. All right. So the previous question,
Yeah.
I understand the poster to be talking about a situation where the person is, because he says the person is due overtime, but is not paid,
Mm-hmm.
which suggests that, as Dr. Bassey said, there was no prior arrangement, and that's the whole point of it. So I'll just reinforce what Dr. Bassey said. With some of these things, notice. So if the person has already entitled to, they should get it. It is not after they've done it, then you tell them, oh, this is what we've done. We don't work during this period, so we'll just take that as your compensation. It doesn't work like that. So if his question reflects what he's trying to communicate, that the employee has done the time, so the employee is due their compensation for the overtime, then the right has already accrued, and they're entitled to have that right vindicated or fulfilled. Going forward, what the employer may want to do is to make these things clear ahead of time that this is the arrangement for the work. If the work is seasonal, during this season we don't work. So whilst we are working, these are the hours, and then we take annual leave. So annual leave is due. Sorry, I'm continuous after being in service for 12 months. How the 12 months that may depend on each employment, on when you started working. However, what I want to stress here is that it will inform each employee through the HR department, if there's one, of when they are to take their leave. Usually, in many situations, you are just there, you are just working. Then, when you feel you're tired, you apply for leave, and then some of your days may be approved, and they will say we are approving out of 20. So, two things that I was saying. First, to answer that question directly, annual leave is a year. You work continuously for a year. If you have not worked, as ordinarily speaking, you're entitled to annual leave after every continuous year of service. And what I want to add to it for everyone's education is that first, it is the duty of the employer to you when you are on leave. If that does not suit you, because you want to use your leave, you may apply or come to some arrangement with your employer. That's first. And two, you are actually entitled to the full annual leave at once, although you may divide the leave.
Wow. Okay. So annual leave is supposed to be due you after working for a year. So if you've not done a year, then you are not entitled to the annual leave. Kofi, is that a summary of what you mentioned?
I'm sorry, could you repeat that?
So I said annual year is supposed to be due or is supposed to be due a person or an employee after working for a year. If the person has not done a year, it means the person is not yet entitled to annual leave. Is that?
I'm sorry, I think that my connection is misbehaving, but if you want me to clarify, so to put in a practical situation, if you start working in January of 2025, then you are entitled to take your annual leave from January of 2026, not December, not necessarily December, but January 20 continuous period.
Okay.
Period of a year, and then you take either February or depending on which day in January you take the annual leave, and if it is the standard 15 days.
Okay. All right. We'll take one last question because of our time, and then we'll be out of here. So Nadia is asking, what is the right way to transition fixed-term contract staff to permanent staff? Can the employer give the contract staff another fixed-term contract after the first one, which was for the term of 12 months, expires?
Yeah. Is that question coming to me, please?
Yes, Jeff.
Yes. What the right way to transition a fixed-term contract staff to permanent staff? Can the employer give the contract staff another fixed-term contract after the first one, which was a term of 12 months, expires? Now, generally, we say that a job that is available and continuous should not be given on fixed-term contract staff. It must be a permanent contract. And let me warn employers listening to us. I mean, very gentle warning to them that you must be very careful when you are issuing fixed-term contracts to people, especially when you can renew the contract several times. It gives an indication that the job is available and continuous. I did a case at the Labor Commission for a lady with one of the banks, and this was the heart of the case. And that was the case we easily won because the contract had been renewed 7 good times, 1 year contract, no, 9 good times, because she was with the bank for 9 years. So now let me get to the heart of the question. Can that fixed term be moved to? The answer is generally yes. You don't necessarily need to continue renewing it. Like I said, unless the job is project based. I mean, when you get to some mining firms, for instance, they renew contract only to the tune of the life of the mine. You cannot give contract to people beyond the life of the mine. But I've had some real experience. I don't know how many people probably are aware that Tallow Oil, for instance, was relying on fixed-term contract staff who were fundamentally being given by an agent. With time, when we had to move the fixed-term contract workers to permanent staff, I was the consultant in charge of that project. The advice I gave to the company, which indeed was approved and supported by the chief labor officer, was to bring the fixed-term contract to a complete closure, bring it to an end. Then you make new offer to them in the name of a permanent contract. Otherwise, well, to the extent that you are not reducing a permanent contract staff to now fixed and renewable, but the other way around, there'll be no issues of jubilation. I mean, you haven't worsened the condition. The employer may not take you, the employee, the worker, may not take you on, and so you may go scot-free. But the general advice is that always bring the contract to an end and begin a new one. And don't just assume that you are permanent, now we want to make you fixed term, or you are fixed term, now we want to make you. There's no that automatic switch over. There must always be bringing a contract to an end, and then you begin a new one. That generally will be my advice. I have tested it with a few organizations, and sometimes when we have even had to end up at the National Labour Commission, the commission most of the time supported our position on this matter.
Okay, thank you very much, Jeff. Kofi, would you like to add anything to it?
No, in this case, I think that Dr. Bass has covered.
Okay. All right. So thank you all for joining this session. This is all time will permit us to do for today. This has been the Q&A on the labor laws of Ghana, proudly brought to you by the HR Certification Center. And we hope you are leaving with a clearer understanding of what makes a contract of employment valid under Ghana's Labor Act, and especially how to apply it in your workplace. So if you like to go deeper into Ghana's labor laws, gain practical skills, and to be able to use it in your everyday activities, we will encourage you to enroll for the legal training for HRs and line managers here at the HR Certification Center. So this program is specifically designed for professionals who want to master employment laws, and they want to be able to handle workplace issues confidently and also stay compliant to the laws of the country. You can see the numbers scrolling down below. Just take it, reach out to the admissions officer, and then you'll be able to get more information on the program. Dr. Bassi, your final words.
Well, my final words will be to encourage our listeners, particularly HR practitioners and other managers who are in charge of people. Not only if you're a line manager, an HOD, a functional head, you work with a team, you under people, and it pays to
Hello, Jeff. Hello, Jeff. Can you hear us?
I think that the network is doing its weekend thing again. But what I would say, if I can pick up from where he left off, from where Dr. Bassi left off, concluding words are first, as this program is seeking to do, I would encourage everyone to try and know more about your conditions of employment. Most people have terms of employment, whether written or not. Try and be refreshing your memory about them. Also, the HR Certification Center is always there to provide expert training if you want to go beyond. You are an employer or somebody in a supervisory role, an HR manager or something like that. It's also important to know what is required of end up in unnecessary and costly, time-consuming litigation. That is what I would say. And our relationship is not one where it is X versus Y, a mutually beneficial outcome. Thank you very much.
Thank you very much, Kofi. And I can see Dr. Bassi has still not been able to come back on. Nonetheless, we are very, very grateful. Special thanks to all our speakers. We are very, very grateful for you sharing your knowledge and your insight with us on this faithful weekend. And to our very, very august listeners, we want to say we are grateful. Thank you for sharing your time with us. And we wish and hope that what we have studied or learned here today would not just be one of the let me hear and forget about it issues, but this will be something you can apply in your workplaces and you can also apply in your day-to-day living. Once again, this is the Q&A session proudly brought to you by the HR Certification Center, and we are grateful for your time. Enjoy your weekend and see you next time. It's bye for now.
As HR leaders and functional line managers, decisions that we make daily can have legal implications. From recruitment to onboarding, discipline to termination, every step must be in alignment with the law. With this, we have put together legal training for HRs and line managers. This course is designed to give you the knowledge and clarity to lead lawfully. We will break down Ghana's Labor Act 651 in a simple, practical way. You will learn what the law actually says and what that means for your work. Do you know the probationary periods or how to properly document issues to prevent future legal risks? These are the things that are really important as a leader and to safeguard your organization. Whether you're a seasoned manager or a new business executive, this course is simply designed for you. To join our next cohort, call or WhatsApp 020-800-7585. It's your time to hop on the legal train.
Why do 93% of the world's leading multinational companies prefer certified professionals? Because they tend to be committed to higher standards and ethics and maintain an informed intercultural competency. Whether you're seeking to build a career or to upgrade your HR professional career, you need to get trained and certified at the HR Certification Center today. Our experience in training and certifying HR professionals is unparalleled. We're trusted to offer a comprehensive portfolio of advanced professional credentials for the HR professionals worldwide, and today, more than 500,000 HR professionals worldwide in 125 plus countries proudly maintain our credentials as a mark of higher professional distinction. HR Certification Center. Call or WhatsApp today on 0244 122 855.
HR Certification Center commits to a higher standard. HR Certification Center commits to a higher standard. HR Certification Center commits to a higher standard.